Nature of the Commission on Appointments. The Commission on Appointments shall be constituted within 30 days after the Senate and the House of Representatives shall have been organized with the election of the President and the Speaker. Article 6, Section 19. It is not mandatory to elect 12 senators to the Commission before it can discharge its functions. What the Constitution requires is that at least a majority of the membership. From the case in Gona versus Gonzalez, 1992. The Commission on Appointments shall act on all appointments within 30 session days from their submission to the Congress and shall rule by a majority vote of all its members. The power to approve or disapprove appointments conferred on the CA as a body and not the individual members. Pasatev versus Secretary of Commission on Appointments, 1971. Jurisdiction of Commission on Appointments. The Commission on Appointments shall confirm the appointments by the President with respect to the following positions. Heads of executive departments, except if it is the Vice President who is appointed to a cabinet position as this needs no confirmation. Ambassadors, other public ministers or consuls, officers of the AFP from the rank of colonel or naval captain, other officers whose appointments are vested in him by the Constitution, example, regular members of the Judicial and Bar Council, chairman and commissioners of the Civil Service Commission, Commission on Elections, and the Commission on Audit, members of the Regional and Consultative Commissions, Remitta versus Mison, 1987. Congress cannot require that the appointment of a person to office created by law shall be subject to Commission on Appointment confirmation. From the case of Calderon versus Carale, 1992. Appointments extended by the President to the above-mentioned positions while Congress is not in session, or the so-called ad interim appointments shall only be effective when 1. Until disapproval by the Commission on Appointments, or 2. Until the next adjournment of Congress. Powers of Congress. 1. Legislative inquiries and oversight functions. Requisites of legislative inquiries. 1. Must be in aid of legislation. 2. Is in accordance with duly published rules of procedure. And 3. Right of persons appearing in or affected by such inquiry shall be respected. Bengzon versus Senate Blue Ribbon Committee, 1991. Comparison between legislative inquiries and the question hour. See Senate versus Remitta, 2006. Okay. What is the difference between legislative inquiries and question hour? What is the constitutional provision providing for legislative inquiries? Section 21, Article 6. Constitutional provision providing for question hour. Section 22, Article 6. Topic of legislative inquiries. In aid of legislation. Topic of question hour. On any matter pertaining to the subject's department. Person subjected under legislative inquiry. Any persons upon subpoena. Person subjected during question hour. Heads of departments only. Appearance of executive officials under legislative inquiries. Appearance of executive officials generally mandatory. Appearance of executive officials during question hour. Appearance of executive officials, 1. Via request, and 2. Upon executive officials' volition with the consent of the President. The mere filing of a criminal or administrative complaint before a court or quasi-judicial body should not automatically bar the conduct of a legislative inquiry. From the case of Standard Chartered Bank versus Senate Committee on Banks, 2007. The requirement of securing prior consent of the President prior to appearing before either the House of Congress applies only to cabinet members and not to other public officials, and only when either House of Congress conducts a question hour, and not in cases of inquiries in aid of legislation, as the latter should be untrammeled because it is coextensive with the power to legislate. The case of Senate of the Philippines versus Remitta, 2006. However, in Gudani versus Senga, 2006, the Supreme Court en banc clarified the above ruling and upheld the President's constitutional authority over the military. The Supreme Court held that Obedience and deference to the military chain of command and the President as Commander-in-Chief are the cornerstones of a professional military on the firm cusp of civilian control. In the same case, the Supreme Court also ruled that any chamber of Congress which seeks the appearance before it of a military officer against the consent of the President has adequate remedies under the law to compel such attendance. Final judicial orders have the force of law of the land which the President has the duty to faithfully execute. If the courts so rule, the duty falls on the shoulder of the President as the Commander-in-Chief to authorize the appearance of military officials before Congress. Additional limitation on the legislative inquiries and oversight function is executive privilege. Executive privilege is the right of the President and high-level officials authorized by her to withhold information from Congress, from the courts, and ultimately from the public. Among the types of information which have been judicially recognized as privileged are state secrets regarding military, diplomatic, and other national security matters. Certain information in the possession of the executive may validly be claimed as privileged, even against Congress, such as presidential conversations, correspondences, or discussions during closed-door cabinet meetings, from the case of Chavez versus PEA, 2003. Since the privilege belongs to the President, only the President can invoke it. She may also authorize the Executive Secretary to invoke the privilege in her behalf, in which case the Executive Secretary must state that the act is by order of the President, which means that he personally consulted the President on such matters. Case of Senate versus Remitta. The claim of privilege must be specific. Example, whether the information sought to be withheld involves military or diplomatic secrets, closed-door cabinet meetings, etc. A claim of privilege, being a claim of exemption from an obligation to disclose information, must be clearly asserted. Congress has the right to know why the executive considers the requested information privileged. It does not suffice to merely declare that the President or an authorized head of office has determined that it is so. If the President and Congress cannot agree on whether the matter is privileged or not, then the court must come in and determine the validity of the claim of the privilege. Elements of presidential communication privilege. In the case of Neri versus Senate Committee 2008, the court ruled that the claim of executive privilege was properly invoked by Secretary Neri, specifically under what is called presidential communication privilege. The elements of presidential communication privilege are: 1. To protect the protected communication must relate to a quintessential and non-delegable presidential power. 2. The communication must be authored or solicited and received by a close advisor of the President or by the President himself. The judicial test is that an advisor must be in operational proximity with the President. 3rd, the presidential communications privilege remains a qualified privilege that may be overcome by a showing of adequate need, such that information sought likely contains important evidence, and by the unavailability of the information elsewhere by an appropriate investigating authority. Contempt power of Congress. As long as there is a legitimate inquiry, then the inherent power of contempt by the Senate may be properly exercised. Conversely, once the legislative inquiry concludes, the exercise of the inherent power of contempt ceases, and there is no more genuine necessity to penalize detained witnesses. Case of Balag versus Senate of the Philippines, 2018. Concept of Congressional Oversight. Broadly defined, the power of oversight embraces all activities undertaken by Congress to enhance its understanding of and influence over the implementation of legislation it has enacted. Clearly, oversight concerns post-enactment measures undertaken by Congress. A. To monitor bureaucratic compliance with program objectives. B. To determine whether agencies are properly administered. C. To eliminate executive waste and dishonesty. D. To prevent executive usurpation of legislative authority. And E. To assess executive conformity with the congressional perception of public interest. Categories of congressional oversight function. There are three. Ang una is scrutiny, congressional investigation, and legislative supervision or legislative veto. Okay, let's start with the first the category of congressional oversight functions. The acts done by Congress purportedly in the exercise of its oversight powers may be divided into three categories, namely scrutiny, investigation, and supervision. Scrutiny. 1. Passive inquiry, the primary purpose of which is to determine the economy and efficiency of the operation of government activities. 2. In the exercise of legislative scrutiny, Congress may request information and report from the other branches of government. It can give recommendations or pass resolutions for consideration of the agency involved. 3. Legislative scrutiny is based primarily on the power of appropriation of Congress. Under the Constitution, the power of the purse belongs to the Congress. 4. Legislative scrutiny does not end in budget hearings. Congress can ask the heads of departments to appear before and be heard by either House of Congress on any matter pertaining to their departments pursuant to Section 22, Article 6 of the 1987 Constitution. Second congressional oversight function is congressional investigation. It is more intense digging of facts compared to scrutiny. The power of investigation is recognized by Section 21, Article 6. And lastly, legislative supervision or legislative veto. 1. It connotes a continuing and informed awareness on part of a congressional committee regarding executive operations in a given administrative area, and 2. Allows the Congress to scrutinize the exercise of delegated lawmaking authorities and permits Congress to retain part of that delegated authority. Through this, the Congress exercises supervision over the executive agencies. Note that legislative supervision is not allowed under the Constitution. From the case of Abacadagoro Party List versus Purisima, non-legislative powers of the legislative department. 1. So, bilaman, there are 1, 2, don't tell me duhara. Please don't tell me there are only 2. Yeah, I think there's only 2. Okay. The first non-legislative power of the legislative department is informing function via legislative inquiries. The conduct of legislative inquiries is intended to benefit not only the Congress but the citizenry who are equally concerned with the proceedings. Case of Sabia versus Gordon, 2006. 2 is the power of impeachment. The House of Representatives shall have the exclusive power to initiate all cases of impeachment. Section 3, subsection 1, Article 10. Initiation. Regular procedure. Section 3, subsection 2 and 3 of Article 11. The filing by any member of the House of Representatives or any citizen upon endorsement by a member of the House of Representatives, followed by referral to the proper House of Representative Committee, that is the House Committee on Justice, committee report by proper committee, which either favorably or unfavorably resolves the complaint. Okay. So, katong kang Estrada, di naman siya atukuan, but he is a citizen. Endorsed by a member of the House of Representatives. Okay. The above resolution is affirmed if favorable or overridden if unfavorable by vote of 1/3 of all members of the House of Representatives. Verified complaint or resolution under Section 3, subsection 4 of Article 10 is filed by 1/3 of all members of the House of Representatives. Trial by Senate forthwith proceeds. Notes on initiation. Gutierrez versus House of Representatives. No impeachment proceeding shall be initiated against the same official more than once within a period of 1 year under Section 2, subsection 5, Article 11. Initiation means filing coupled with the referral to the Committee on Justice. The court cannot make a determination of what constitutes an impeachable offense. It is a purely political question. On motion to inhibit, impeachment is a political exercise. The court cannot apply to congressmen the stringent standards which ask of justices and judges when it comes to inhibition from hearing cases. Constitutional requirement that House of Representatives shall promulgate its rules on impeachment under Section 3, Subsection 8, Article 11 is different from the publication requirement in Tañada v. Tuvera, 1985. Trial. So after the initiation is the trial under power of impeachment. The Senate shall have the sole power to try and decide all cases of impeachment. Section 3, Subsection 6, Article 11. By virtue of the expanded judicial review, Section 1, Subsection 2, Article 8, the court's power of judicial review extends over justiciable issues arising in impeachment proceedings. But the question of whether or not the Senate impeachment rules were followed is a political question. From the case of Corona v. Senate, 2012. 10-3-60-10 rule. 10-3-60-10 rule. So many. 10 days, a verified complaint for the impeachment must be included in the order of business within 10 session days. So 2 weeks bale. 3 days, after the lapse of the 10 days, the complaint must be referred to a committee within 3 session days. 60 days, the committee, after hearing and by majority vote of all its members, shall submit its report to the House within 60 days from such referral. And 10 days, the resolution shall be calendared for consideration of the House within 10 session days from receipt thereof. Initiative and referendum. We're almost there, ba? Initiative. Local initiative, voter requirements. If autonomous region, there should not be not less than 2,000 times number of voters. Barangays not less than 50 times number of voters. Where to file regional assembly or local legislative as the case may be. Section 13 RA 6735. Limitations on local initiatives. Cannot be exercised more than once a year, extends only to subjects or matters which are within the legal powers of the legislative department or local legislative bodies to enact, and if at any time before the initiative is held, the local legislative body should adopt in toto the provisions presented, the initiative shall be cancelled. Section 15, Article 6735, Referendum. This refers to the power of the electorate to approve or reject legislation through an election called for that purpose. Classifications of referendum. Referendum on statutes. Petition to approve or reject an act or law or part thereof passed by Congress, and the second one is referendum on local laws. Legal processes whereby the registered voters of the LGU may approve, amend, or reject any ordinance enacted by the Sanggunian. Is the power to hold a referendum plenary? No. Such power is circumscribed by the following limitations. A. Petition embracing more than one subject and shall be submitted to the electorate, and B. Statutes involving emergency measures, the enactment of which is specifically vested in the Congress by Constitution and cannot be subject to referendum until 90 days after effectivity. Thanks.